Good afternoon. We have now called a meeting to hear the appeals case in front of the Cobb County Board of Zoning Appeals. Mr. Rawlings?
Thank you, Chairwoman. My name is Bill Rolling. I'm the Cobb County Attorney. Just want to go over a few of the steps that we have for this particular proceeding. An appeal has been filed to the board for your consideration. It's my understanding that one of the board members is not present today and the other board member has recused himself from his participation in the second meeting, Mr. Boulogne. Okay. The hearing was timely filed. Each party has a right to file a position paper related to their prospective position regarding the case. My understanding those have been presented to the board prior to this time, and one's going to be presented to me shortly. As far as the hearing procedures themselves, if there are any pre-hearing motions to be heard, they can be heard prior to the beginning of that. I'm not aware of any that have been presented to me. Each side has 3 minutes to make an opening statement. I'll keep the timer here and let them know when their time is running. Of course, the timer's on the podium as well. Each side then has a cumulative time of 20 minutes to make their presentation of their case. If the opposing party questions their witness at any point in time, that is counted against the other opposing party's time. If the board asks questions of a witness or makes questions of the appellant or the appellee during the hearing, that is not taken against their time. I'll keep track of it here, about how much time they have to be able to present and how much time is left. The board, at the discretion or at the request of either the party, could also extend the time as you normally would during any BZA hearing or variance hearing. They then have 3 minutes for summation. After that occurs, then it comes back to the board for them to make for you to take up the matter and rule on the matter at that point in time. Let me see. At the conclusion of the hearing, the reviewing body may issue a ruling or may take the case under advisement. In the event that the reviewing body takes the case under advisement, then there's specific rules you'd have to follow. Of course, you cannot deliberate unless you're all together at one time. You cannot discuss the case. You cannot receive any additional emails, any additional information. Everything that's going to be made as part of your hearing or deliberations has to be received today during this hearing. Okay. If there's any questions that arise that are of a specific legal nature, you are able to adjourn into executive session. We can't adjourn into executive session to figure out if we can go into executive session, but if you ask me a question, I'll let you know if I can answer it now or if it needs to move into executive session. Otherwise, all deliberations regarding the case are public. Okay. With that, I'll turn it over to the chair, or you can turn it over to the appellant in this case, Ms. Gambrell, for her presentations.
Ms. Gambrell.
Thank you. My name is Kelly Gambrell.
Can we ask, is it proper to go up to the podium so we can hear?
Sure, sure.
We're asking you that is much clearer for us to hear than that particular microphone. Thank you. Appreciate it.
It also has the timer on it too, so that might be advantageous as well.
Yes, thank you. My name is Kelly Gambrell. I am the adjacent homeowner to the Maffey's property. I have been involved with this property since 2005 when it came in for rezoning. Prior to that, in 2003, when we moved into our home, we knew the land behind us was undeveloped. We asked what could be put there. We were in agreement that it would be homes similar to ours. Lo and behold, the yellow zoning sign went up and things rapidly changed. Our neighborhood fought this zoning case. It was very contentious. It was very drawn out. In the end, the homeowners did agree to the end development with the understanding we were going to have a 40-foot buffer to help protect our neighborhood from the neighborhood coming in. Not only from a visual perspective, but also knowing that we were a young, active family, and this was going to be a senior development moving in. We understand seniors like quiet enjoyment. We also know young families are out with their kids playing. After that, several things happened. Development started to happen. the land was raised 6 feet behind my house, and I started having property damage due to water, which then put me back in front of the board almost weekly for public comment, bringing my issues to light, asking for help and remediation from the county. It was then Chairman Sam Olens directed then Community Development Rob Hozak to work with me to help resolve the issues. You will notice on a couple of the site plans that there was a swale inserted, which did alleviate some of the water problems, but then in 2013 a fence was erected, and that fence then prevented the water from flowing off of my property, actually caused it to flow back onto my property, which then again put me in front of the board. From there, development started. The buffer was planted, it was growing and serving the purpose it was. In 2015, the homeowner adjacent to the Maffeys, who is not part of this complaint today, hedged the buffer. To that, I called in to Rob Hozak, reported it, they came out, and I was told that they would not hedge the buffer again. So the question becomes, is if they could not hedge the buffer in 2015, why are they allowed to remove the limbs and the branches from the lower part of the buffer, which removes and takes away the purpose of the trees, which are to have a full and well-branched or dense bladed buffer adjacent to ours? That is all. Thank you.
Good afternoon. My name is Debbie Blair with the County Attorney's Office, and I am here representing code enforcement. You will be shown that code enforcement's decision is correct, that there is no violation of the zoning conditions or the tree preservation and replacement code that occurred on this property when the owner of 451 Winding Ridge Circle caused an arborist to trim existing trees within that buffer. While Ms. Gambrell, in her appeal, attempts to raise some questions regarding zoning stipulations themselves, those issues are not before this board. The sole issue to be decided by you today is whether or not code enforcement abused its discretion when it decided that there was no buffer violation. Per the county code, the BZA may reverse, affirm, or modify the decision of code enforcement. Appellant contends that in her appeal that code enforcement made the wrong decision because the maintenance violates the zoning conditions, it violates the tree protection plan, and because no permit was obtained when the arborist trimmed the trees in the buffer. However, this challenge must fail. The required buffer is a landscape buffer, which per county code can be maintained. The tree preservation and replacement plan is applicable to the development of property, and it ceases once the development or the project is completed. A property owner is not required in Cobb to obtain a permit to trim trees on their private property. Code enforcement acted within its discretion in interpreting the zoning condition and determining there was no violation of the buffer. The trees continue to be a visual and physical barrier between Appellant's property and 451 Winding Ridge. It will be shown that the correct and proper decision is for the BZA to affirm the decision of code enforcement. Thank you.
With that, Chairwoman, that you can turn it over to Ms. Gambrell for her presentation.
Sure. Yeah. Point at you or
This computer.
right there? Okay. Thank you. Here is a picture of the buffer when it was planted in 2012. I was part of the Landscape Oversight Committee that approved this buffer. The choices of the buffering material were chosen because it was going to create a dense visual buffer within a short period of time. It was approved, a CO was issued, and it began to grow from there. Here is just another visual of the buffer beginning to grow. And if you also look carefully, in this picture you will see a picket fence. That picket fence was about 4 feet in height at the time. If you carefully look, watch in pictures coming down, that fence was eventually changed from a picket fence to a 6-foot privacy fence. And the question becomes is, why was it needed to become a privacy fence? In the position paper that I got from Ms. Blair, Rosa M. Maffey signed an affidavit stating they are aware of the zoning conditions that exist on the property requiring a 40-foot buffer containing a mix of trees on the property or grassed areas. Ms. Maffey then stated no trees had been removed, and while this is a true statement, the maintenance that has been performed in the required buffer as designated by the Board of Commissioners and approved by the Landscape Oversight Committee, the buffer now does not contain trees that are full and well-branched or dense bladed as defined on the Tree Replacement and Protection Plan. And while I understand Ms. Blair stated that this ceases upon approval of the development, it was also included in the stipulations to which Ms. Massey noted in her affidavit she knew were there. And again, this is why I'm appealing the decision of the division manager. The stipulation was placed on the property when applying for the residential senior living because the proposed development is adjacent to a more restrictive residentially zoned property. While arguments can be made that the property was changed to fee simple townhomes, that was just, again, to obtain financing. Ms. Rosa has stated that the removal of the tree limbs was due to safety reasons, yet no credible threat has been presented to support this statement, nor has evidence been presented to show that the trees were damaged, dying, diseased, or being controlled by pests. If these trees were pest-ridden, why would you only remove the lower portion of the tree and not the entire tree, which would then be required to be replanted? The Board of Commissioners also increased our buffer requirements for this property above what code had been required. Here's a picture coming into 2013. There was a letter that I had sent to Mr. Hozak on October 23rd. I do not have a copy of that letter, but I had that noted in my notes from addressing issues on this property. One of the buffer trees here had been removed, and you can kind of see the open gap. In that letter from Mr. Hozak, I was told that the tree would be replanted. Again, this is a year after the property owner had moved in and would have been keeping the buffer in compliance with the code. No tree was replanted to replace the one that was taken out, but instead one of the trees was adjusted and shifted slightly. Also here you can see that the 6-foot privacy fence was then installed, which begs the question of why. You know, we're seeking privacy to our property, which was granted to us through the Board of Commissioners through a stipulation to provide extra privacy, which has now been removed. In 2015, I did call code enforcement on the neighbor to the south of the Macy's. Here you can see where they essentially hedged the top of the bush of the trees. My understanding is that code enforcement went out, Mr. Cecil Atchley, who was our arborist at the time, and while I do not have it in writing, I was told that the homeowner was advised not to hedge the trees anymore, so that way the trees could grow to their full height and fulfill the purpose of the buffer, which was a visual buffer. Here is a picture taken just the other day of what that buffer now looks like. You can see that the trees that were at the corner did grow to their anticipated height, while the ones in the center are lower due to the hedging that was done in 2015. But it also has provided the visual screening that was expected. This is the Massey's property, which, sorry for the sun glare, but again, you can see where they had hedged the buffer at some time as well. The expectation of privacy from a policing perspective varies. If you're standing on a public right-of-way or a private road, the expectation that you have complete privacy within your home is not viable unless you have limited windows or placed blinds up to prevent those from outside looking in. I know privacy was considered, or safety was mentioned as a reason for taking the limbs off the trees, but as you can see here, this is standing at the corner of my driveway. My house would be to the right, my neighbor is to the left, and the Massey's house is in between. And it would be in between, but to the left of my home. From here, you can clearly see into their back windows. You can see into their yard. So if safety is an issue, by removing those limbs, they have actually opened themselves up to less privacy than before. From a landscaping perspective, per the plan, deciduous trees were planted in the fronts of the homes only and clearly showed a crown type of appearance. These trees were planted for aesthetic appeal, which creates an inviting character to the community. Most people enjoy the privacy of their backyard, as the expectation is that you can engage in activities without being watched from a public road. Ms. Rosa has, under the guise of landscape maintenance, changed the purpose of the required plantings, which was to form a dense screening between properties. Ms. Rosa has not provided evidence to support that the limbs removed were dead or had a pest problem, and it is highly suspicious that pests would only impact the lower portion of a planting. Screening as defined is a natural or man-made feature which separates land uses. Screening buffers and landscape requirements address visual, light, and sound impacts. Screens and buffers can enhance community appearance and reduce land use conflicts. Since the removal of the limbs, Ms. Rosa now has a light that shines directly into my kitchen seating area. Again, no credible threat had been provided as to the safety concerns, nor have I been notified by police that a credible threat has been made, yet the quiet enjoyment of my own home has now changed. Here is a picture of the buffer shortly after the trimming was done. As you can see, more branches and trees are now dying from the maintenance that was done. And then here's the picture of the buffer the day that I reported it to code enforcement as far as a violation. Therefore, I ask this board to uphold the original intent and purpose of the approved landscape plan and direct the homeowner to replant the trees that have been compromised, thereby allowing full visual screening as was achieved prior to the November 16, 2021. No hardship or documentation has been provided to support the claim that the trees had dead limbs, pest, and safety reasons in doing so to have them removed. In addition, it is not uncommon for the Board of Commissioners nor the Board of Zoning Appeals to put conditions such as buffering on properties to provide such screening. Therefore, I asked for it to be upheld as originally approved in 2015. Thank you. I yield my time, but reserve it for response.
To hand out a copy. Do you want me to hand this out, or do you want to? This is a
Ms. Blair, you're going to need to address board through the microphone.
You can't hear me? I have asked the clerk to hand out a copy of the position paper that I had filed with the clerk, a copy of the presentation that I will be making momentarily, as well as certified code that is mentioned in the position paper. I have shared this with Ms. Gambrell, and she is fine with it being part of the record. I'll be right back. I would like to call my first witness, Mr. Dave Griffin, please. Mr. Griffin, if you would raise your right hand, please.
Ms. Blair, I think you're going to probably either need to hold the mic or we get some CP can give you some direction. Is that fine?
Yeah, if you can hold it, that'll work.
This on. I love masks. Mr. Griffin, if you would.
There's a delay.
I didn't turn it on. Hello? This one's on. Hello? Hello? Mr. Griffin, thank you for raising your right hand. Do you swear or affirm that the evidence that you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Would you please state your name for the record?
David Griffin,
And where are you currently employed?
in the Cobb County Community Development Association,
And how long have you been with the county?
for 17 years.
And what is your current position with the county?
I'm the Site Plan Review Manager, and in that role, I serve as the supervisor of the county arborist and landscape architect.
Have you held any other positions with the county?
Yes, for 12 years, I served double duty as the county arborist and landscape architect before I took my current position.
And what is your educational background?
I have a bachelor's degree in landscape architecture from the University of Georgia.
And do you hold any professional certifications?
Yes, ma'am. I am a registered landscape architect. I'm a certified arborist. I'm a certified floodplain manager and a certified erosion control expert.
Wonderful. Do you regularly attend continuing education seminars and/or conferences?
Yes.
How many years have you worked in the field of landscaped architecture and arborist?
29.
So you had 12 years before coming to the county?
Yes.
And as far as the county code goes, what is the purpose of the tree preservation replacement plan code?
It is imposed on new developments. It requires a specific density of trees on a new development, and the density is established by saving existing trees or planting new trees or a combination of the two.
And as far as the effectiveness of the plan as to a property, does it continue in perpetuity?
No, the tree ordinance is imposed on the developer or the builder, and then once the property is in the, after a CO is issued, once it's private property, it's no longer subject to the tree ordinance.
Is a permit required to trim trees on an owner's private property?
No.
When is a land disturbance permit required?
When there is disturbance of 1 acre or more, or disturbance within 200 feet of state waters.
Okay, and switching gears a little bit, is there one or more types of buffers referenced in the county code?
Yes, the code provides 3 types of buffers. There is a planted landscape buffer, there's an undisturbed buffer, and there is an enhanced natural buffer.
And when, what is the type of buffer that is required on this particular property as a result of the zoning condition?
It was a planted landscape buffer.
Is that buffer, can you maintain that buffer per the code?
Yes.
Why might maintenance be required on a buffer?
To improve the health of the trees within the buffer, to remove dead, dying disease trees, and to remove non-native invasive species.
And does maintenance or trimming of a tree cause it to die?
Not if it's done properly.
And you visited 451 Winding Ridge Circle recently, is that correct?
Correct.
And why were you at the property?
The county arborist was first asked to look at this violation request, and he made his comments to me that he did not feel that it was a violation, and so I was asked to take a second look along with Ms. Pickett from Code Enforcement.
Are you or someone from your department regularly involved with code enforcement when there are allegations of a buffer violation?
Yes.
Describe how the trees on 451 Winding Ridge were trimmed when you were out, what you observed when you were at the property.
They had been limbed up from the bottom, so the bottom branches had been pruned off.
And is that a typical type of maintenance, or?
It's not unusual, yes.
Is it your belief that these trees will fill in as the growing season continues?
Yes, the remaining branches will continue to flush out, and the lowest remaining branches on the tree will, as they fill out, they will sort of sag and fill in any gaps.
Okay. Does the zoning condition on this property state that the buffer should be undisturbed?
No, it does not.
In its current condition, is it your opinion that the trees on the property provide a visual or physical barrier between the two properties?
Yes.
In your professional opinion, did the property owner violate the buffer condition in the zoning stipulations?
No.
Okay, thank you. Ms. Gambrell, your witness?
Mr. Griffin, I don't know if you can answer this question, but you stated that the tree preservation, let me say it correctly, and the tree replacement and protection plan was not in perpetuity. However, there are stipulations on this property that reference this buffer. So it was my understanding that stipulations were something that were put on this property above what code allowed, which means that would be the governing document. So how does that change? Which document prevails? Is it the tree protection and replacement plan, or is it the letter of stipulations that specifies it was a 40-foot buffer, and then at that time also had attachment as to what that buffer was to look like?
So the buffer regulations and the zoning stipulations are in perpetuity. The tree ordinance portion of the plan is not. So this was sort of an overlap. The buffer material was shown and included in the tree plan, but in general, from a high level, the tree ordinance portion of any plan is not in perpetuity.
Right, but you said this was an overlap of the two, which means the stipulations are in perpetuity on that property until it's rezoned or removed by the Board of Commissioners. Has the Board of Commissioners removed this stipulation?
No, the buffer portion still remains.
Thank you. And then when you were asked if it was usual for a tree to be limbed up from the bottom, you said it was not unusual, but the question was, is this typical?
I wouldn't say it's typical. These are large evergreen trees, and most of the time they're planted and they're left on their own to grow. But I've seen plenty of these that have been pruned up like this.
And when you were out there, did Ms. Rosa Maffey show you pictures of the trees prior to having the limbs removed because they were dead, damaged, or pest-ridden?
No.
Thank you.
I have one other question, please. You stated that the buffer is not an undisturbed buffer, which means that there is maintenance allowed on these trees. If a property owner, does a property owner have to have a dead or diseased tree in order to maintain trees?
No, they can be pruned for maintenance. They can be, even fertilizing is considered maintenance. They don't need to be dead or dying in order to prune out individual dead branches or to improve the overall shape and health of the tree.
Okay, no further questions. Thank you. I have no further witnesses, but I do have a slide presentation. It's up and down or side to side? Okay. This here is details the timeline of the appeal. Ms. Gambrell mentioned a little bit about the history of this property. This property, 451 Winding Circle, is in a subdivision by the name of Cobblestone Ridge. That was zoned in 2005 as a senior living community. And as Ms. Gambrell said, there was a lot of opposition to the development, but the BOC did approve the development, requiring a 40-foot buffer to be along the Alexander Farms property line. The current and only owner of Ms. Gambrell's home, not Ms. Gambrell, the owner of the home behind Ms. Gambrell's home, Ms. Maffey, has lived there since 2012. She regularly maintains her trees, and the action of in 2021, November, she trimmed the trees, and that is the cause of this appeal. To orient you to the properties, Ms. Maffey's home is the property that is outlined in blue. The home directly behind is Ms. Gambrell's property. It has the cursor is on top of that property. You must determine in this appeal today whether or not code enforcement abused its discretion when it decided that there was no violation of the buffer. An abuse of discretion is found when a decision is made without any evidence to support the decision and contrary to law and equity. Discretion is defined as the exercise of judgment based on what is fair under the circumstances and guided by principles of rules and law. In this case, you, the BZA, must affirm the decision of code enforcement if there is some evidence in the record to show that the decision was proper. You will be shown this evidence. Appellant alleges that the tree preservation plan for this development was violated. However, as has been stated by Mr. Griffin, the tree preservation plan is a tool used during the development process. It does not continue into perpetuity. The preservation plan was submitted for this development and was constructed according to the plan. This was reflected by the fact that the project was finalized and final certificates of occupancy were issued. This is the existing zoning condition which applies to 451 Winding Ridge Circle. There is nothing in this condition, as has been stated, that shows that it is an undisturbed buffer. It does not have to be an undisturbed buffer. The next slide is the definition of buffer in the county code. As Mr. Griffin described, there are undisturbed buffers, maintained natural buffers, or landscape buffers. Unless a buffer is described in the condition as undisturbed, it can be maintained. The trees and fence on 451 Winding Ridge serve as a visual and physical barrier and meet the definition of the code as it exists today. I believe you saw this particular photo in Ms. Gambrell's presentation. This is a photo from 2013. We have an aerial view of the property in 2014, and you can see this photo and the prior photo. This is the buffer, or the condition of the buffer when it was planted. Obviously, it was intended to fill out, and that's exactly what it did. This photo, again, I think this photo was in Ms. Gambrell's presentation. This was provided to Ms. Pickett when the complaint was made in November of 2021. These photos were taken by me when I visited the property on February 1st, and they were taken from the small patio at the back of the home. As described by Mr. Griffin, you can see that the trees were only limbed up. In addition to the zoning condition not requiring an undisturbed buffer, County Code also allows for maintenance of buffers in the RSL zoning classification. Based on these photos, you must determine if there is any evidence to support code enforcement's decision of no buffer violation. I believe that the photographic evidence, as well as the testimony, show that there is no abuse of discretion in this decision. Code enforcement requests the BZA to uphold its decision of no violation of the required buffer and to deny appellant's appeal in its entirety. Thank you. I have Ms. Pickett here if there are any questions of her, as well as Mr. Griffin.
Well, you're complete, Ms. Blair?
Yeah, my presentation is complete.
Okay.
I can make a summation if.
Well, I was going to turn it back over to the board before a summation was
Okay.
offered. If the board had any questions that you would have for any of the witnesses or any of the materials that you've been provided, or if you want to take a break and look at any of the materials and ask any questions, now would be the time before there was a summation that was being offered.
So just to simplify, we're trying, the board is going to make a decision whether or not code enforcement violated a review or inspection or
Whether the decision that was made by the witness that was presented was an abuse of discretion, that his decision was, and I think the standard is abuse of discretion, which is the adjudicator's failure to exercise sound, reasonable legal decision-making. That is for the hearing board to decide whether it was grossly unsound, unreasonable, illegal, or unsupported by any evidence. That's the decision that you have to make regarding the witness's decision in this matter. And you can ask any questions you want to of the witnesses. I just don't want them to go to summation at this point in time. If there's any questions that you have or any material, you were given a packet of materials if you wanted to review that or any of Ms. Gambrell's evidence and ask any questions.
can I make a statement?
May I speak? The property owner's representative is here and wants to make a statement.
Okay. The property owner, under our hearing procedures, does have a right for the same 10-minute presentation to be able to make that. To answer your question, I mean, you can make a statement, yes, or do you want to hear from the property owner first?
We can hear from property owner
Okay.
first, please. Thank you.
Good afternoon, Commissioners. My name is Jeff Cox. I am the son of...
I'm sorry, Mr. Cox, can you hold on 1 second? I just want to get my timer straight here.
Sorry.
Yes, you should be. Mr. Cox, if you'd raise your right hand, please. You solemnly swear the testimony that you're about to give before this board be the truth, the whole truth, nothing but the truth?
I do.
Okay. Mr. Cox, there's a timer that's on the board. You can see it where it's 10 minutes. That's the time that you have.
Okay.
And just for the board's enlightenment, under our hearing procedures, if the aggrieved party is not the property owner, in this instance, the aggrieved party is the Ms. Gambrell is not the actual property owner. The property owner or its representative may fully participate in the hearing or elect to simply make a 10-minute presentation to the reviewing body. So we would take it from this witness, if you'd state your name and your representative of that person.
Okay. Good afternoon, Commissioners. My name is Jeff Cox. I am the son of Rosa Maffey. I live here in Cobb County as well. My mother is a widow of 3 years, lives by herself in a seniors community. A lot of residents in that community seem to be in a similar situation, so I think they all are in need of having the best interest taken out for their safety and their well-being. The property, as my mother's was appearing, with all of the branch growth that was so far down, was becoming, to me, a hazardous and safety risk because she lets her dog out in the backyard, which is fenced. It would be easy for somebody to hide in the shadows under the bushes or behind bushes as the way it was set up. There are instances, and I don't know if Ms. Gambrell's taken the effort to look very far into the complaints, but Ring Doorbell as a community posts every time there is an instance of intrusion on a property or theft on a property. My mother has a Ring doorbell, so she gets frequent updates. Within the last 3 months, in a 1 mile radius of the neighborhood, there have been over 100 Ring doorbell notifications of package theft, property damage, property theft, other types of incidences. So it is a documented problem. Cobb County Police may not have that on their ledgers, but it is a documented problem. Because of that, I recommended my mother limb her trees up no higher than 5 feet because she has a 6-foot privacy fence across the back of the yard. The 5-foot level allowed to open up the bottom. I put floodlights underneath that she could see what was in the backyard when she exited for her evening to let the dog out. My concern about this isn't about a few branches or a few limbs. It's about the overall safety of my mother and also the neighbors around her, because quite honestly, if somebody could hide in one backyard, they could do damage to any of these neighbors. As far as limb health or not, I will tell you, and the arborist probably could reinforce this, several of the trees that were planted by the builder were Leland cypresses. Leland cypresses die from the bottom up. As they get taller, the bottom branches die. They become browned out, burned out. The picture Ms. Gambrell showed with the browned out dead leaves, branches, they did not happen after the pruning. Those were already present when we pruned. We just didn't happen to prune all of those that were browned up. They were a little higher than we wanted to go. As far as pests, I wasn't talking about bugs and insects. I'm talking about rats, squirrels, and raccoons. Those also like low-lying branches to hide in and nest in. My mom's dog would go out and chase raccoons out of the backyard on a frequent. So pests beyond bugs and infestations like she was describing did exist. I'm only here to represent my mother in the fact that she didn't do anything to violate the ordinance. She did not do anything to violate this do not disturb buffer that Ms. Gambrell believes exists. She has a right as a property owner to maintain. I'd probably say the county would enforce it if she didn't maintain it properly. If I'm not understanding that correctly, they would force her to clean her backyard up if she happened to be a hoarder or a pack rat. This is just a matter of somebody not being happy with a few branches or a few leaves being taken off, and I think that's petty. The fact that this commission had to take up time to rebut an appeal that the commission the commission had already said was not violated, it just seems to be a lot of whining. So I'm sorry you guys have had to spend this time today. I will just tell you, we will continue to maintain the property so that it is a representable piece of the community, has value for the whole community and for the property, but it is not a violation of any part of this ordinance that Ms. Gambrell believes is in place. Lastly, we observed after I had to get involved in this, I didn't even know who Ms. Gambrell was, so I had to figure out where is this complaint coming from. I happened to take a minute to walk out to the back of the fence line to see what would be her problem, what was the disturbance that she believed. I had to literally look over the fence to even see her house. While I looked over the fence, it was kind of an interesting thing. I know Ms. Gambrell is a county commissioner, and I think she serves on some committees that are related to landscape and ordinance and property rights. I looked in her backyard. What did I see? It was a burn barrel. Cobb County ordinance says burn barrels are prohibited. So this is a side note. I know it's not related to this, but we have a county commissioner who seems to think the rules and rights pertain to her only and not myself. And
I
have
object,
pictures- I have
Mr.
pictures.
Rowling.
Yes, excuse me, sir.
Evidence is being entered into that is not in consideration
Oh,
in this
okay.
hearing.
That's fine. Well, we can file a complaint like you did. That's fine.
Sir,
So-
sir,
Yeah.
please address your comments to the
I am.
board.
I'm sorry, she addressed my comments, so, okay. So I guess that's the extent of it, but my frustration about this is this was nothing done to be harmful to any other neighbor. As a matter of fact, it was done in light of trying to protect all of the neighbors. Crime is a problem in that area. Senior citizens especially are being preyed on, as you well know. You hear it in the news. This is it's just a flagrant abuse of somebody's power as a committee member as far as I'm concerned. But that's my opinion. Thank you.
Sir, if the board has any questions, or either Ms. Gambrell or Ms. Blair has any questions, they're allowed to ask questions. It would be counted against your particular time. Ms. Gambrell, you have first choice. And you have, I'm just letting you know, you have a total of 8 minutes left right now, is my calculations. So, and your 3-minute summation is separate from that. So.
Yes, thank you. So, Mr. Cox, you admit that you put floodlights into the back of the yard?
I put low voltage directed spotlights that are no more than a foot off the ground. They do not shine upwards, so they would not be floodlights you see.
Yet I have shown pictures of those lights shining into my backyard.
Not those lights. You could show me those pictures, I'd prove it, but that's all right.
That
Also, one
picture
of the other
was,
pictures you showed in your presentation was not my mom's backyard, it was her neighbor's backyard.
Sir, you should just leave your comments just to the questions being asked of you.
you also stated that there were Leland cypresses. I would like to have Mr. Griffith come back forward, because according to the site plan that I have for the tree protection, there were no Leland cypresses planted. So, Mr. Griffin.
Ms. Gambrell,
Only address my question. Okay.
sorry, wait.
I'm sorry.
Just questions with the witness now, and then Ms. Blair would have an opportunity with the witness, and then the board, but then you do have more time to bring him back up if you want to.
Okay, thank you. Mr. Cox, you are stating that I am using a blatant abuse of my position and power. Are you aware that all citizens have the right to appeal a decision made by a staff member or a zoning member or any member of the county?
I sure am. As a citizen of
Thank you.
Cobb County, I realize we all have those rights, but it doesn't go beyond me to recognize that you are also on several committees related to zoning and planning and landscaping. So you do have a conflict of interest.
Mr. Rowling, I say this witness is out of order.
Sir, if you would just answer the question.
Okay. And to the comment about the Leland cypresses, I may have mistakenly given you the name of a species. They could be cryptomerias. So if I mistakenly described it, but they both grow the same way. They're both evergreen trees that are fast growing, and they do die from the bottom up. All right, is that all?
Ms. Gambrell, is that it?
I'm done with this witness.
I have no questions.
Okay. Does the board have any questions before the witness leaves the podium?
I just have a quick question. Getting back to you had stated floodlights and then the discussion with Ms. Burrell. What kind of lighting system do you have in the back on the property? Can you describe it?
Sure. On the home itself, the builder installed dual spotlights on the corner eaves, probably standard to plan for every home in the neighborhood.
And those have been on the home since it's been built?
Since it was built, yeah, prior to my mother buying it. Those are the same lights that are still in existence. The only lights that I've added are solar-powered, low-voltage, mini spot beams that shine under the trees, under that foliage that we had to take out, so that she could see a full view from fence line to fence line of her backyard. So there was no potential. She could look out and see if there's anybody in the backyard.
So they're solar powered?
They're solar powered. They're low voltage, maybe 12 watts each. They are not floodlights by description that Ms. Gambrill gave. They are not floodlights, and they are definitely not high enough up that she could even see them. They sit a foot off the ground, and they shine across the grade level. They're not even shining an upward level. You may have caught a couple of pictures of those when you're out, but
Are they shining towards your mother's house, or are they lights that cast?
they're shining
360
from the grass line, the way her yard is situated. Half of it is grass, turf. The other half is covered in pine straw where the trees are. They're sitting at the grass line so that they can have a view of the solar. If they were back in behind the trees, they wouldn't have a solar view. So they're there. But because that yard has a double 6-foot privacy fence, I can promise you, nobody can see that light through either one of those fences. That was another question that was interesting to me. I thought I'd bring this up.
That was, I think, I don't know if you can continue, because you
Oh,
answered
okay.
my question.
Okay, you're asking me
So thank you
questions.
so much.
Okay.
Well, I have a question. With respect to the spotlights that are fairly common on a lot of neighborhood light or homes for security purposes, those lights can be angled down, right? So they're not as obtrusive to the neighboring properties, basically.
Absolutely. I've angled
Has
them.
that been attempted? Do you know?
They already are that way, yes, sir. And I've checked them, and I've even replaced bulbs, so I know that they're oriented that way. They're angled down. The ones to the right-hand side of each light set are not even angled toward the neighbor's yards. They're all within our own yard, my mom's yard, excuse me. They're angled down. They only come on with motion sensor, so they're not even full-time lights. They're
Yes,
motion sensor.
I understand.
Yeah,
Thank you.
you're welcome. Okay.
You both asked the questions I had, so thank you.
Now we're back to if the board had any questions for any of the witnesses that were presented. Otherwise, or if you wanted to take a break and review any of the materials that you had and then come back, that's an option as well. Otherwise, we'd move into summations from both of the parties.
I would like clarification on what is planted there from code enforcement, since you're an arborist.
So what is out there now is a combination of cryptomeria trees, which is a pyramidal needle leaf evergreen, as well as Yopon hollies. And I didn't do an inventory when I was out there, and I think there's also some American hollies out there.
Good, thank you.
Okay.
So no
Can I-
cypresses or arborvitaes? It looked like there might have been
I'm sorry, say again?
no cypresses or arborvitaes?
No, we actually don't allow Leyland cypress to be planted to meet either tree ordinance or buffer requirements. They grow fast and they die fast, so the cryptomeria is similar size and shape. There's just a much higher quality tree.
Thank you.
So the cryptomeria, there's no diseases that are associated with them, because I know Leland cypresses have had this disease that is relatively new that's creating them to die because they were used for buffers in the past. So the cryptomeria, are there any issues with regards to them?
They're not disease-free, but they're certainly a much hardier tree than the Leylands. They're not as susceptible to near as many as the diseases and pests and pathogens that the Leylands are.
So in order to keep their life, because these are rather large trees, who is responsible in this landscape buffer to, I'm sure that there needs to be some fertilization, some sort of maintenance. Are these trees that are in this buffer just, they grow fine without any treatment whatsoever?
The rezoning stipulation, I believe, states that the homeowners association is responsible for the maintenance of the buffer trees.
The homeowners association that,
That's not correct.
I'm sorry.
Okay.
Sir, you just need to limit your answers just to what you know, not what you speculate or guess.
Okay.
Ms. Blair, I'm sorry. They still have this witness available for you.
Okay, so I'm done. Thank you very much.
Okay.
You might have another question?
Yeah.
There's a chestnut.
Just as a possibility, with the density of those trees as we currently see them, trying to go through and do underplantings to fill in, what's the viability?
It is feasible. They would have to be shade-tolerant species like azaleas and hostas, things like that.
Okay. Okay. Any other questions for him?
Maybe a stupid question, but I'll ask anyways. To me, this seems to be like a security and a security issue or a buffer zone. And these trees that were trimmed down and whatnot, there may be some gaps. Is there a way that those gaps can be filled with appropriate vegetation so as to not impact the cryptomerias or hollies that are planted there right now?
Not easily. They would have to, whatever's planted would have to be 5 to 6 feet tall at installation, and to close the gap between the bottom of the trees and the top of the fence, there's not a lot of daylight in between there, so they'd have to be pretty good-sized trees. It would require a pretty good-sized root ball.
What about through offsetting them a little bit?
I mean, they could be staggered or spread out. They could be moved out from under the trees. But, the larger they are, the larger the hole has to be dug for them. And that's going to impact the root system of the evergreen trees, as well as there's some hardwood trees on the adjacent property that could be impacted by these as well.
To go along with the line of it impacting the person's ability to see, because the limbs were down and it's dense in the backyard, to see if there's anybody back there, I can understand. Is there, so you're saying that in that buffer area that you would recommend not, it may impact the other trees, the healthy trees there, if you plant like a low-level bush, not maybe something that doesn't get as high as these enormous trees, but something that would kind of be a low-level bush that still would be able to give the lady that lives there the ability to look out to make sure that no one can hide behind these trees or these bushes. I guess do you have any suggestions of what could help mitigate the issue of having these bare spots? And then in the pictures we saw some light reflection. Is there something that you could recommend that would take care of the issue of safety, and then Ms. Gambrell's issue of having her yard, her buffer exposed to the lights and some.
That's a tough question. The center of that Venn diagram, there's not a whole lot of species that would provide screening, evergreen screening, while not creating a safety issue or blocking her view of the backyard. Again, they would have to be, anything you plant in order to provide any meaningful screening would have to be 5 or 6 feet tall. And, they would have to be full enough to provide the screening, but at the same time, that's going to defeat the purpose of limbing the trees up, which they performed.
So one last question about the trees is that you had said that so they limbed these up. Will there be low growth again, or is these trees going to continue growing and creating more of a space from where it was limbed to over the fence? My understanding is that these trees were trimmed just, a foot below the fence line, but are these going to start growing taller and there's going to be exposure even more as they grow? Or do they start filling out at the bottom with limbs? Or is that all done at the top of the tree?
Yeah, the growth comes from the top of the tree, so the bottom limbs, they may raise a little over time, but in general, they're going to stay about where they are. But they'll also continue to fill out and grow as the tree gets larger, and as they grow, they'll continue to sag, and so they'll fill in the gap below where they are now.
So to keep them healthy, so they continue to grow and sag, do you recommend some type of maintenance system to these trees to make sure that there isn't a continuation of these limbs dying as they grow? Because they're a little more exposed than they were before.
Not anything out of the ordinary. Just anytime a dead branch appears, they should be pruned out, as in any landscape, maintained landscape buffer.
Okay, thank you.
One more question, please. Abrevieties, they grow, they're fairly slim, I believe, and they grow fairly tall. And you can get them pretty mature. Any reason why they can't be planted in between some gaps, to fill in the gaps, to satisfy the buffer issue and eliminate the potential of the spotlight, interfering with Ms. Gambrell's property?
They could be. They would need to be planted in front of the existing trees so that they don't grow up into the cryptomerias and the hollies.
Right. I mean, my understanding is they go fairly tight. They don't really expand much.
There's
I'm talking about abrevieties, not giant
right.
abrevieties.
Yeah, there's a smaller one it's a large shrub, small tree that would probably be sufficient. The emerald arborvitae.
Okay. That's all I got. Thank you.
Any other questions or presentations that the board would care to hear from?
Mr. Rowland, excuse me, I'm the homeowner, and if there's any opportunity that I could just say just a small piece.
The representative of the land had approximately 3 minutes left. It's board's discretion. Her son's already spoken, but he did not use all of his 10. He did not use all of his 10-minute time. It's fine. Maybe approximately 3 minutes.
Do I need to be sworn in?
Yes, ma'am, you do. You solemnly swear that the testimony that you're about to give before this board on the matter that's before them be the truth, whole truth, nothing but the truth, so help you God.
I do.
Okay.
Yes.
Please state your name, where you live.
Hi, my name is Rosa Maffey. I am the homeowner of 451 Winding Ridge Circle, and I only take 2 seconds here. This is not the first time I have done since my husband passed away. Prior to that, he took care of everything. And I have a little mini golden doodle that likes to collect all the limbs. So about every other year, I have paid a landscaper to come in and raise the umbrella up so that when Brady goes underneath there, we don't have, I've seen rabbits in the yard, other critters. I pay exterminators to make sure this stuff goes away. But this year, actually hired an arborist to do the trimming. And the first thing I said to them when they got there, the second visit, do not trim those trees above that fence. And I work from home, And when he came and knocked on the door, they was through. I went back and looked at the job. I can't glue them back on. I went, you trimmed them too short. I'm sorry. Well, and here I am in a situation that I can't glue those limbs back on. I can't make a 10-foot privacy fence. I will say that the pictures that Ms. Gambrill showed from her front yard of her house, that she stated that my house was the one to the left, that is not my house. That is my next door neighbor who removed all of the trees from the buffer. And I have never touched mine. So I just want to explain, this is something I do about every other year because they end up just laying on the ground and I can't see under them. And that's really all I wanted to say. Okay?
The board, of course, the board has opportunity to ask you questions if they care to.
I have no question, but I have a question for you.
Yes, Ms. Swanson.
So in her statement that it's the wrong house has been identified, but it's a house next door that has removed trees from there. So are we going down? What are we? We're looking now at the buffer, and you know, I'm going down looking at the buffer of her home, and that's what's in this hearing today, correct? Not the buffer of the next door neighbor that has potentially removed.
Correct. If you have a question related to that issue, I'm sure Ms. Gambrill would be able to assist you regarding the picture that she took and the light that she had.
And I guess that's one.
Ma'am, I'm sorry.
I think that, thank you.
Okay.
Does anyone have a question for her?
I just wanted to clarify that point because I do know by that pecan tree that is in her next door neighbor's yard that we all live with, but that house to the left of that picture belongs to my neighbor, whereas I'm the one on the right directly behind her, Miss Gambrill's house. I cannot see her house from my backyard. I would have to literally go out to the fence, which I'm not real sure-footed, so I'm not going to do that, to even see her house.
Thank you, ma'am. I appreciate you explaining that. All right. Can Ms. Gambrill come?
Mr. Rowling, I have a question for Ms. Maffey.
Oh, sorry. Yes.
Do you have security cameras on the back of your house?
Pardon?
Do you have security cameras on the back of your house?
Objection, that's not at issue today.
This is,
I object. Her son brought that up
no.
in his statements.
Ms. Blair, excuse me, ma'am, hold on one second.
Okay,
When we start
okay.
talking, we just wait until we get back to you. It has been brought up by another witness. I think it's a fair avenue that Ms. Gambrill can at least pursue at this point in time. That would be my ruling suggestion for the board. Okay.
Okay, so I thought he mentioned my Ring doorbell, which is on the front of my house. It's not on the back of my house. I do have motion sensors in the back of my house so that, you know, they go off if there's motion out there. And I probably could point that to Ms. Gambrill's back of her house and it still wouldn't pick anything because I really cannot see her house. I just know it's back there. I have a one-story house with no windows on the back side of my house, so I would not have that functionality of going upstairs and looking out. I just have I do have an upstairs, but I don't have windows on that side of my house. So it's just a one-story visibility to the back.
So to answer the question on cameras, you have a Ring doorbell in the front of your house, and you have motion sensors, but no cameras on the back.
There is a camera pointed at my back door.
Towards your back door?
Toward my back door.
Okay.
Yeah. The only time it goes off is when the wind makes my screen door move. So,
Okay.
Because I intentionally do not point that. And there's only one of them, and it points towards my screen door on my porch.
Thank you.
Other than the
Can I
front, I
make
do
a
have one on
comment?
the front.
Can I make a comment or statement? I mean, is there an issue with the security cameras, or
Is that-
is that something that we need to consider?
It was brought up, so it was a fair, reasonable inquiry that Ms. Gambrell can then follow in. She may have something else that she would like to talk about with that. So, I don't know.
Yeah, it's a little Arlo camera. It doesn't have real wide, like, range anything other than the bird that sits on my screen door if I leave it open.
I'm good.
Ma'am, I think you're complete. I think that's it.
That it?
Yes.
Okay.
Again, it comes back to the board on if there's any additional witnesses, or if you want to review the documents,
Can I
or
just make
if
a-
moved to summation for the parties.
Can I make just a quick request, is that, I think it was Ms. Gambrell that had the pictures of what you
Yeah.
now see with the buffer, just to establish the question that Ms. Malfi said about it not being her backyard.
CP, can you assist her with the presentation?
So this is the current picture.
My house is on the right.
Mr. Rowling, can I call point of order?
Ma'am, you can't make any comments during this point in time.
As I said earlier, my house in the front of the picture sits to the right. So I've got the basketball court, and then you see my garage door and my fence to the right. Do we have a pointer?
You can,
Oh, okay. But I don't have the mic. Oh. Okay. So this is my house right here. This is Miss Mappy's house, which is adjacent to mine, which, as you can see from here, you can see to the back of her house. You can see, she claims there are no windows, but if you look carefully underneath the trees, you can see the windows that are actually probably on her now screened-in porch right there. And no, the property next to me was never in question as far as buffering, because that, again, is not adjacent to my property line.
Okay.
Ms. Gambrell, where are the spotlights?
So,
sorry, go back that way.
okay.
I need it.
So this is taken out of my kitchen window. I'm going to have to jump between pictures here. So essentially, that is about the corner of where that light would be coming through, then into my kitchen. What you also need to remember is this property sits approximately 6 feet above my property in the backyard. So it does change the view depending on which side of the fence you are standing on.
Can you leave this picture? So in this picture, this is a recent one, correct?
Correct.
With the limbs that are dying in that?
Mm-hmm.
So is that, since this is a landscape buffer, is that something that would need to be trimmed because this could create other issues for this tree as it continues to grow?
Well, interestingly enough, I'm going to change the picture on you here if I do it the right way. That is the picture that I took on November 16th when I came home and saw that the trees had been trimmed. If you carefully look, there are no dead or dying limbs now. The picture here shows that now we have additional tree limbs dying. And the question is it because of the trimming that was done on November 16th? Because this is the most recent picture. Compared to the one on the 16th, where you do not see any dead or dying limbs.
Thank you.
Brian, do we, any other questions?
No, I don't have any other questions.
Mr. Rowling, can we make a decision with stipulations?
Yes, you can make a decision with stipulations, but both of them have the right to make the summation before you get to that point.
Yeah,
So,
I think, yeah, we're good.
okay. Ms. Gamble has the right to go first.
Thank you. Again, all I'm asking here today is for stipulations that were placed back in 2005 to give a buffer that all at that time was, in all intentions and purposes, to provide screening between two adjacent property owners. In regards to the position paper that Ms. Blair handed to you, on page 4, it says, see the affidavit of Rosa M. Maffey attached as Exhibit F. She is familiar with the landscape maintenance that has occurred on the property, and none of these trees originally planted have been removed. She regularly maintains the trees and plants on the property to remove dead limbs, prevents pests, and for safety reasons. Ms. Maffey stood up and said that she had hired an arborist to do this work. If she has been doing this work since 2012, since she moved in, it was never an issue or concern and never had breached the visual buffer until now. So again, it begs the question of why was the intensity of the trimming or the lifting, if it had been done over the years, it had been not noticeable to the community. As far as the reference to the tree replacement and protection plans, again, we have a stipulation letter that clearly defines this 40-foot buffer that then references this site plan as part of an attachment. Therefore, it is my opinion that that site plan still is applicable and the expectations that that buffer stay in perpetuity. On that plan, it clearly states that the trees are to be full and well-branched or dense blade. Ms. Maffey, in removing the lower limbs, has taken away the full branched purpose of those trees. Again, my property sits 6 feet below the subject property. As far as maintenance, again, we had not seen maintenance done to this extent over the 10 years that she has been on the property. We understand maintenance. We do maintenance ourselves, and we are routinely picking up limbs and branches from our neighbors' trees. We don't complain because we enjoy their trees. So we do understand maintenance, but the action taken on November 16th was beyond maintenance. As far as safety issues, it sounds like there's motion sensors and such in the backyard that would potentially alert a neighbor. I know from myself and my adjacent neighbor who could not be here today, we have no safety concerns in our neighbors. Our cul-de-sac, we have pretty much either rings or cameras on every person's door, and we feel completely safe in our neighborhood. The question as far as, the sagging of the tree. Yes, this tree will sag, these branches will sag, but as we're seeing in the most recent picture, are these causing these limbs to sag too much because they don't have anything underneath to help support them? And will they continue to die off going up the tree, further removing the protection of the buffer?
Ms. Gambrell, I'm sorry, your time's up. Do you want additional time?
No, thank you, just that I request that the buffer be replaced. Thank you.
I would like to point out 2 slides that are in the packet that I gave you. There is a slide that shows the left, middle, right photos, and the slide immediately before that was taken by Ms. Gambrell, December 2021. Thank you, CB. In the slide with the left, middle, right, the two slides on the left-hand side, well, the left and the middle, excuse me, show the landscape lights that were discussed earlier. The solar lights, thank you. So that is the lighting that is there in the buffer. I guess I just want to point out, in this picture, a buffer needs to be a visual and a physical barrier between the properties according to our code. This particular property has a 40-foot buffer requirement. When you look at these photos, you cannot see that there is a house behind these trees. We know that there is a house behind those trees, but I believe that code enforcement looked at these photos, looked at the trees on the property, they were in this backyard, and the decision that they made that there is no violation of the buffer was the correct decision to make on this property. Again, the decision that you make today is whether or not code enforcement abused its discretion when they made that decision. The abuse of discretion is there any evidence to show that there was a violation of this buffer? When you look at these pictures, there is simply no evidence to show that the buffer does not exist as it was intended when the zoning condition was put on this property in 2005. Thank you so much for your time, questions, and I ask that you deny the appeal in its entirety. Thank you.
Any other questions? So at this point in time, we either make a decision or we take a...
Correct. At this point in time, well, if you want to, you could take a break. You cannot do any deliberation that isn't public, but you could review the materials that you provided to you. You can entertain a motion. You could have open discussion if you want to amongst the three of you regarding next steps. You could delay a decision to be made at another point in time in the future. That is allowed as well. And I have, if you'd like to do that, there's specific rules regarding that as well.
But you can make a decision and put stipulations on this buffer?
I'm going to read, if I can.
Yes,
I prefer to read specifically what the code section allows you to do. In exercising the powers described in subsection A, which in this instance is hear and decide appeals where it is alleged there is an error in any order, requirement, decision, or determination made by an administrative official in the enforcement of this chapter, which in this essence would be a code enforcement. So this is an appeal related to that decision. In conformity with the provisions of this chapter, this board can reverse or affirm or modify that order or requirement or decision or determination that the code enforcement officer made.
Can I make a motion then?
Certainly.
Okay, I like to make a motion. First of all, I appreciate both sides. Presentation was done very professionally, and being a HOA president for 10 years, I've heard this many times, not in settings like this, but I make a motion to deny the appeal, that there was no abuse of just discretion by code enforcement, with a stipulation, because I did see some trees that appear to be dying, whether or not that was from the trimming, I don't know, through infestation or disease, I don't know, and I don't think that has been determined. But my stipulation would be that any trees that are dying, any buffer trees or vegetation that needs to be removed and replaced, be removed and replaced. And also, as I was trying to discuss earlier, if there are any gaps and any means to add more buffer, that be entertained as well. That's my motion.
Okay. Do we have any discussion? We need a second. Do I have a second?
I second.
Okay.
For discussion.
Would you be willing to modify, okay, somebody's going to help me on this modification stuff. Modify it to be a little bit more succinct, and also, I was thinking of a motion to say, going forward, to not raise the canopy any higher than it exists today, unless it's, I mean, it could naturally happen, but any aggressive pruning. So
I'm fine with that modification to the stipulation.
I think we need to probably restate this for clarity. Sir?
Please.
Yes, because I didn't hear all of it. And of course, if you could restate it after the motion is seconded, it's the board. So as long as there's a consent from the board to modify it, then you can.
I think Mr. Russell wants to modify my stipulation to also include that the canopy or anything below the 6 foot, anything below the fence, if you will, cannot be trimmed or removed without, it.
Okay.
I don't know the correct wording, but if there is disease or if there is infestation that is going to potentially impact the growth of that tree through the review of an arborist or whatever, that that be considered before any trimming is allowed. Is that clear?
I have some questions, if I might.
Yeah, hold on one second. Robin's taking down the specific motion.
Yeah.
If you're asking me if it's clear, I'll have to tell you, no, it's not, because the first part of your motion, it says there's no abuse of discretion, and then you're changing everything. So that's not clear, because if you found an abuse of discretion and then you wanted to modify or you wanted to reverse or...
No, I don't want, I find no, I denied the appeal of no abuse of discretion by the code enforcement. I'm just saying, I'm just asking if we can make a stipulation with it.
Well, the stipulation that you presented, I would contend, is outside of your boundary, because it's not contained in what the order has. We can't, the landowner here is not a party to this particular hearing, okay? The only thing that's presented before the hearing is whether the code enforcement officer's decision that there was no violation is an abuse of discretion or not, so.
So there's nothing so in this instance, there was, to agree that there was no code of violation, but we can't do for future. What's going to stop for future? I guess
that's not our concern. Is what will protect this buffer from future.
If you want to,
violations?
okay, if you want to get to, if you believe the code enforcement officer should have taken additional actions, then you could find that there was an abuse of discretion, and then you could modify what he ruled in a way that would address those issues. You're allowed to do that.
I think this is unlike when we're hearing the variance where we actually can put some stipulations in. This is if we want to say he acted correctly, that is just to clean that decision. We cannot add stipulations as we do in our other BZA actions.
Correct. That's the discretion. That's the standard. Like in a criminal case, beyond a reasonable doubt. Here's the abuse of discretion. If you found there was an abuse of discretion, then you could modify it. You could add stipulations like you just described, however you want to do that.
Okay.
The buffer has to be maintained regardless going forward, right?
That's part of the.
I mean, the buffer.
The buffer has to be maintained, yes.
Okay.
So there is mechanisms in place at this point in time for code enforcement standpoint, to know how to continue to maintain the buffer. Is that?
Correct.
Well, code enforcement doesn't maintain the buffer.
No,
They're
but-
only called out there. They're
Yeah.
not there.
But-
Code enforcement doesn't drive around to check buffer maintenance. They're only there when there is
A violation.
somebody that is called into code enforcement to say that
Yeah.
there is something, so it's
Yeah.
after the fact.
Yeah. Well, I
For the most
misspoke.
part, yes.
I misspoke in the fact that if something occurred again, then the parties are responsible for dealing with it through the county.
Well, we
Yeah.
could come up back up here again.
Yeah. So, do you want to?
Do I need to revise my motion then to state specifically that that I make a motion to deny the appeal, that there was no abuse of discretion by code enforcement?
Well,
Do we need to?
we have a pending motion. If the motion is, since it was seconded, is before the board.
Yeah.
So you can offer that as a motion before the board, and it's whether you can get consent of the board for that or not.
Okay, then I'm totally, okay. So, do we need to, does Mr. O'Malley need to withdraw his original motion and make a new motion that's just very precise?
He just offered a substitute
Yeah,
for it,
okay.
as I understood what he
Are
said.
you, okay, I just want to be sure we're following
Yeah.
protocol.
Yes.
Okay, all right.
I'll second it.
And can we just, Robin, do you have that specific motion, what he said? If you just read it back for the people who see.
Yes, please.
I have that Mr. O'Malley said he wanted to deny the motion. There was no abuse of discretion.
Deny the motion or deny the appeal?
I'm sorry.
Okay.
I didn't feel that there was no abuse of discretion.
Okay.
I second it with just the comment that it's very hard to have a buffer. You know, I understand buffers, and I understand them putting into variances or putting them into zonings. It's very hard to put something that's living, breathing, as a complete buffer, because they can die, they can be pruned, they can be a deformed tree. So it's very hard to keep it in perpetuity, this big dense buffer. Over time it's gonna get old. Those trees are gonna get older and maybe thinner due to nature. This is a buffer that isn't like a natural buffer where you cannot touch it. So I just would hope that all parties look at doing your due diligence of preserving this and kind of as a learning tool about doing the right thing with these trees that are in your yard, and that I think that you all know each other, so I think that there could be some communication between the people, your neighbors in the back, as to what you feel your part of the buffer is doing, and sort of have have some sort of a discussion before you call people in to do pruning or maintenance. But I think that, in my opinion, the only buffers that you can put that will stay in perpetuity is a big 40-foot wall. And again, they might crumble. But I just feel that in all this discussion and everything we heard, and that you're all neighbors, not of the same neighborhood, that there could be some neighborly communication of trying to do what's right for this buffer, which benefits both sides of this property, but both developments.
All right. Excuse me.
So that's just my little side note as to why I support the motion.
Yeah. Are we ready to vote? Okay. Please enter your votes. 3 yeses. Motion passes. So, do we have any other business? Do I see a motion for adjournment?
A motion to adjourn?
Second.
All right.